Australia had no full legal independence until 1986. Not 1901, when the colonies federated. Not 1942, when Australia formally cut ties with Britain during World War II. 1986, the year of Top Gun, the Chernobyl disaster, and the Challenger explosion. That's how recently the United Kingdom's Parliament still technically had the power to write laws for Australian states, and Australian court cases could still, in theory, end up decided by British judges in London. The images in this video are AI-generated visualizations based on documented historical research, not authentic archival photographs. This is the story of the 85-year hangover nobody talks about. How a country can raise its own flag, fight its own wars, and still not fully own its own laws. On January 1st, 1901, 6 British colonies merged into a single country, the Commonwealth of Australia. It's the date every Australian learns as their nation's birthday, and fair enough, it's when the states first got a shared parliament, a shared government, a shared identity. Here's the part that gets left out of the school version. The document that created Australia wasn't an Australian law. It was a British one, passed by the Parliament in Westminster, given royal assent by Queen Victoria in July 1900. Australia's entire founding document was, legally speaking, a piece of UK legislation that happened to apply to a continent on the other side of the planet. And crucially, the British Parliament kept the power to override it, amend it, or legislate for Australia directly anytime it wanted to. For the first 3 decades of the Commonwealth's existence, that power sat mostly unused, like a gun nobody expected to actually fire. Australia ran its own domestic affairs, built its own parliament, fought its own war in Gallipoli under its own flag. But the legal authority underneath all of it was still, on paper, British. In 1926, Britain made a promise. The Balfour Declaration declared that Commonwealth countries like Australia, Canada, and South Africa were equal in status to Britain itself, autonomous communities within the empire, in no way subordinate to one another. It took 5 more years to turn that promise into law. The Statute of Westminster, passed by the British Parliament in 1931, formally ended the UK's power to legislate for the Commonwealth nations, at least on paper. But Australia didn't actually adopt it. Not in 1931. Not for another 11 years. Australia didn't ratify the Statute of Westminster until 1942, and even then, not out of any burning desire for independence. It happened in the middle of World War II, largely as a legal fix so that Australian wartime legislation would hold up without any doubt about its validity, backdated retroactively to 1939 to cover the legal gap. Independence, when it finally arrived on paper, arrived as a wartime technicality, not a national movement. And even after 1942, the fine print mattered enormously. The Statute of Westminster only freed the Commonwealth government in Canberra from British control. It said nothing about the 6 state governments. New South Wales, Victoria, Queensland, and the rest were still, individually, subject to British oversight. Certain state bills still needed the monarch's personal approval. The monarch could disallow a state law within 2 years of it passing. And the advice the Crown received on Australian state matters came through the British Foreign Secretary, not through any Australian official at all. It's worth pausing on how strange that actually is. A state parliament in Australia could pass a law, and the mechanism for the British Crown to decide whether that law stood or fell ran through London's own Foreign Policy Office, with zero formal Australian input in that specific chain. This wasn't just theoretical. In April 1933, Western Australia held a referendum on seceding from the Commonwealth entirely and going it alone as a separate British Dominion. 68% of voters said yes. The state government sent a delegation all the way to Westminster to ask Britain to make it official. Britain said no, not because the referendum failed, it didn't, but because London decided this was a matter for the Australian government to sort out, not for Britain to unilaterally grant. A state's fate hinged on a decision made 4,000 kilometers away by people who weren't in the room, deciding they didn't want to be in the room. That tangled, half-finished authority sat there, mostly dormant, for another 50 years. Why did it take until 1986 to clean this up? Partly, nobody was in a hurry. The relationship between Australia and Britain through the mid-20th century stayed genuinely warm. Queen Elizabeth II made repeated visits, including in 1954, 1958, and 1963, and each one was met with real public enthusiasm. Cutting the last legal threads to Britain wasn't a pressing national grievance. It was unfinished paperwork nobody felt urgent about. There was also a deeper legal tangle underneath. As late as 1985, the Australian Defence Force was still technically operating under old imperial legislation left over from the colonial era, including offenses on the books for things like dueling and genuinely beating drums negligently occasioning false alarms on the march. Nobody had gone through and formally repealed the accumulated residue of a century of British legal inheritance. It just sat there and used, technically valid. The trigger that finally forced the issue was almost identical to the 1933 Western Australia situation 5 decades later. Queensland, in the early 1980s, was making noises about the same kind of secession threat Western Australia had raised, and around the same time, Quebec was making similar noises in Canada. Suddenly, the loose ends in the Commonwealth's constitutional structure weren't just historical curiosities. They were live political risks. Prime Minister Bob Hawke and the 6 state premiers sat down at conferences in 1982 and 1984 and agreed it was time to finish the job properly all at once across every level of government. What they built was, honestly, a piece of remarkably tidy constitutional engineering. Not one law, but 7 near-identical acts passed by the Australian Federal Parliament, by the UK Parliament, and by all 6 state parliaments individually, all timed to take effect on the exact same day. So there'd be no gap, no ambiguity, no state left behind. The Australian version received royal assent on December 4th, 1985. The Queen signed the UK version on February 7th, 1986. And on March 3rd, 1986, by royal proclamation, the Australia Acts came into force simultaneously across the entire Commonwealth. So what did March 3rd, 1986 actually do? 2 things, and they're both bigger than they sound. First, it permanently ended the UK Parliament's power to legislate for Australia at any level, federal or state. The pen, from that day forward, belonged entirely to Australian legislatures. Second, it abolished the last route of appeal from any Australian court to the Privy Council in London, the British judicial body that had, until that point, remained the final word on certain Australian legal cases. It didn't happen with fanfare. There was a ceremony. Queen Elizabeth personally presented Prime Minister Hawke with the original signed proclamation, but there was no national holiday created, no dramatic break, nothing like a flag-lowering moment. Which is, in a way, the whole point of this story. Australia's actual, complete legal independence arrived quietly, 85 years after the date everyone celebrates as the country's birthday, and most Australians have never heard of it. The courts noticed, even if the public mostly didn't. In a 1999 case called Sue versus Hill, Australia's High Court ruled that Britain now legally counted as a foreign power under Australian law, meaning someone holding only British citizenship couldn't stand for the Australian Federal Parliament. In 2003, in a case called Shaw, the High Court went further, describing the Australia Act as nothing less than Australia's own Declaration of Independence, just one that arrived through legislation instead of revolution. One thread never got fully cut, and it's worth mentioning honestly. The monarch remains Australia's head of state. A 1999 referendum asked Australians whether to become a republic, replacing the crown with a president. It failed without reaching the required national and state-level majorities. So Australia's constitution is entirely homegrown since 1986, written and enforced exclusively by Australian institutions. But the ceremonial thread to the crown, unlike the legal ones, is still there because Australians themselves voted to keep it. Most countries get one clean independence story, a date, a document, a flag raised for the first time. Australia got a slow unwind instead. Federation in 1901 that wasn't quite independence, a statute in 1931 that Australia ignored for over a decade, an adoption in 1942 that only covered half the country's governments, And finally, in 1986, 7 simultaneous acts quietly finishing a job that had been technically unfinished for 85 years. It's a reminder that independence isn't always a single moment. Sometimes it's a very long, very quiet paperwork trail, and the country living it doesn't always notice exactly when the last box got checked. If you want more of the history they didn't teach you, subscribe, new videos every week.